your criminal history is not good. I don't think probation is appropriate for you because of that. And because of other things that are in the PSI report.
Welcome to the Court of Justice.
Court is calling 2021 CR 2958 and 2022 CR 8569, State of Texas versus Amethyst Garcia. Can I have parties announced for the record for the state?
Go ahead, Your Honor.
And are you Ms. Garcia?
Yes, ma'am.
Ms. Garcia, in cause number 2022 CR 8569, you entered a plea, and according to the plea bargain agreement, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. State is silent on your application. They're taking in consideration NIMAG number 688702. Have both parties had a chance to review the PSI report?
Yes, Your Honor. With my understanding that the cap was at 4, unless I misunderstood.
No, I'm just reading what's in the,
My understanding is cap at 5. 5?
Yes.
Okay.
all right, have both parties had a chance to review the PSI report, state?
Yes, Your Honor. Yes, Your Honor.
Defense? Any objections to the PSI report, state?
No objection, Your Honor.
Defense? All right. And then, Ms. Garcia, I'm going to show you what's entitled Motion to Revoke Community Supervision and State's motion to supplement pending motion to revoke probation. Did you review those documents with your attorney? Did you understand them? I can't hear you.
Yes, ma'am.
Are you the same Amethyst P. Garcia who's placed on community supervision in 2021 CR 2958 for the offense of possession of a controlled substance, penalty group 1 gram or 4 grams on April 18, 2022 for a term of 5 years?
Yes, ma'am.
All right. State.
Yes, Your Honor. Actually, Your Honor, on violation condition number 1, for the June 9th, 2022, the state would like to orderly amend it, striking the language W/I-D-E-L, which stands for with intent to deliver. Sure. Violated condition number 1, on or about the 9th day of June 2022, in Bear County, Texas, the defendant Amethyst P. Garcia committed the offense of possession of controlled substance, penalty group 1, 4 to 200 grams, in violation condition number 1.
How do you plead to that? True or not true?
True.
Yeah, and we'll waive the remaining violated conditions.
All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. I'm assuming there is no agreement on the motion to revoke.
That is correct, Your Honor.
All right. And the state is silent on 2022 CR 8569. And that cause number, defense, do you have any witnesses?
Oh, yeah.
All right, then the court will hear argument.
Well, on the, are you saying for the application for probation?
Yes.
Yeah, the application for probation. Now, when we were, trying to negotiate all of this, MTR and everything, so my understanding is, and of course, right now I'm saying it's different, but my understanding is that the MTR, agreement for the, for punishment would be to run concurrent or to run together with the case that she plead on. So that's what, on that new case, Your Honor, we're asking this court to give her another opportunity. Now, she did not comply with her probation. In fact, she, as Your Honor can read, she didn't even start her probation. She didn't show up for orientation or anything like that, which caused the warrant and everything to come in. Now, she's realized she's been in jail since November of 2022. She realizes that this has to stop. And she picked up a new case. It doesn't get any better because it gets worse as you go along. However, I'm asking this court to give her another opportunity. And why should you give her another opportunity on probation is because I think that she realizes that this has to stop. She had a death in the family of her grandmother last year that was her mother figure. She lost a brother who also contributed to her mental state, which made her do bad judgment. So we're asking the court to give her the opportunity to go on probation, do things right, go back, because she's got 5 daughters to go home to, which are in the hands of their family. She has a father that is there, that is willing to support her, and she also has a job that's waiting for her if when she gets out. So we're asking the court to give her the opportunity. It's a second opportunity. I know that the facts in her case don't warrant it, but we're asking the court to do so. Because I had long conversations with Ms. Garcia, and I can tell the difference in attitude as to what she has to do in order to continue on with her life. Now, the TAP evaluations are recommending SAP, and SAP right now is, I know it's a long waiting list, and it'll be maybe a year, a few months before she goes to SAP. But we're asking the court to follow the other alternative, which is the outpatient treatment, and put as many requirements on her for her probation to do the outpatient treatment. That way she can go to work, she can go take care of her children, and she can prove to this court that she, and I'm not saying she learned her lesson, I'm just saying she had learned that she has to stop. That's the only words I can come up with. She has to stop. She has to grow up and be there, a parent for her children. And I'm asking the court for probation.
All right. So anything you wish to say, Ms. Garcia?
Yeah, it shouldn't have used it, is it?
All right, do you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. You're gonna have to make sure you keep your voice up. State your name for the record.
Amethyst Garcia.
All right, what would you like to say?
That I apologize, that I was in the wrong, that I used an excuse when it's not an excuse, and I've acknowledged that now. I'm not saying that, oh, no, that's the time. No, I know that I have to do what I need to, and I do have 5 daughters, 9, 8, 7, 6, and 5. And I need to be there for them. I do have a job lined up. I do have support from family, and it's time to go on with my life and to carry on and do what I need to do as a woman, as a mother, and do what I need to do.
All right. Ms. Garcia, I'm looking at your criminal history. And sometimes people are learning their lessons, but your criminal history is not good. And when I look at criminal history, I'm not necessarily looking at it to say, oh, this person is a bad person. I'm looking at it to see, has there been any type of intervention? Has somebody learned their lesson? Is there anything that I can do to protect the community and have this person be an, productive member of society? And I'm looking at your history, and there have been plenty of interventions for you, and you have not taken advantage of any of those interventions. And I don't think probation is appropriate for you because of that. And because of other things that are in the PSI report, the fact that I previously had you on probation to work with you. And I think any defense attorney in this courthouse, in this courtroom, will tell you that when I put people on probation, I'm hoping that they will be successful, and I give them conditions to have tools to be successful. And I always ask people, when I place them on probation, I always ask them, is there anything else they need from the court to be successful? And what you've done since you've been on probation is not report. You just picked up new charges, and I can't have that. All right, the court is going to sentence you to a $1,500 fine, time and money. I'm sorry, in cause number 2022 CR 8569. The court will sentence you to a $1,500 fine, time and money to run concurrent. This will run concurrent with 2021 CR 2958. 5 years in the prison. Take in consideration NIGHTMAG number 688702. Give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Because this is a plea bargain agreement, because I followed your plea bargain agreement and you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Now, if you would like, because I do see the TAP evaluation, they're recommending that you do inpatient treatment. If you would like, I could recommend you for the therapeutic community. It is a drug treatment program. I cannot force them to put you into it. All I can do is recommend it, and then you will have to recommend it yourself. It does not increase the amount of time that you're in custody. Would you like to be considered?
No. For being in custody, he wants to don't do it. Would you explain again, Your Honor?
All right. So the therapeutic community, I do not have jurisdiction to force them to place you in the therapeutic community. The therapeutic community is a program at the prison that will hopefully help you with any drug issues you have. If you're accepted into the therapeutic community, it does not increase your prison time. So for example, in this case, you've been sentenced to 5 years prison. If you're in the therapeutic community and you do not complete it, they're not going to say, oh, she didn't complete it in 5 years, so we're giving her 6 years. If you're up for parole and they deem you're parole worthy at 2 years, they're not going to say, we're giving her parole. We would give her parole, but because she hasn't completed the therapeutic community, we're not giving her parole. So it's merely a program to help you, hopefully, with any drug issues you have. All right, and we'll do a request for therapeutic community. All right, next we're going to move on and cause number 2021 CR 2958. The court found violation of condition number 1 true. The court will sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 8569. There's to be no contact with Antonio Reyes, Reyes. And there is a $1,500 fine, time and money to run concurrent. And that cause number I'm showing you, and I'll request the therapeutic community. And that cause number I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? I'm sorry?
Yes.
All right, this has not been a plea bargain agreement, so you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes, ma'am.
All right, and because that is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, again, you'll need to speak to your attorney. Do you understand?
Yes.
All right, we can go off the record. Ms. Garcia, I know you wanted probation. Your attorney told me about your daughters. When you get out of prison, you need to make sure that you stay on the straight and narrow so you can be in their lives. All right. All right. Good luck to you. Court is calling 2022 CR 0502 State of Texas versus Daniel Masters. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
Defense. And are you Mr. Masters? All right. I'm going to need you to speak up so I can hear you. Okay. All right, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Daryl Daniel Masters, who is placed on deferred adjudication in cause number 2022 CR 0502 for the offense of aggravated assault with a deadly weapon on April 13th, 2022 for a period of 5 years. Is that you? All right, state.
Violated condition number 2, on or about the first day of September 2022 in Bexar County, Texas. The defendant, Daryl Daniel Masters, did then and there fail to submit to drug testing as directed by the court/court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 4, in Bexar County, Texas. The defendant, Daryl Daniel Masters, did then and there fail to report to the supervision officer as directed for the month of September 2022 in violation of condition number 4.
How do you plead to that? True or not true?
And will waive the remaining violations.
Any objections to the state's waivers?
No objection.
All right, did you understand by pleading true to violations 2 and 4, the court could find it true, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violations 2 and 4? All right, the court will find 2 and 4 true. Is there an agreement?
Yes, Your Honor.
And what is the agreement?
We ask that you find the violations true, that you continue the defendant on community supervision, and that you amend the conditions of probation to include safety special needs.
All right, is that the agreement?
That is the agreement.
All right, Mr. Masters, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. So what is going on? Why are you not doing your drug testing? All right. So I see that he was with Esperanza Court.
Yes, she didn't do that. Apparently. And he got some mental health problems. And some drug problems too. I think.
All right. So this is what I'm going to do. I'm going to deny the motion. I'm going to alter the main conditions to include a re-referral to Esperanza Court. And we can do safe P. So if safe P special needs. So if Esperanza Court doesn't accept you back, then you'll be going to safe P. Do you understand? All right. Here's the thing. You need to open yourself to receiving help, because nobody can help you if you don't want the help. So if there's a reason for you not doing drug testing, if it's going to be that you're going to be positive, you need to own it. If there's a reason for you not doing Esperanza Court because you don't want to face the fact of where you are in life, you need to own it. At the end of the day, where we are currently in life is not where we're going to end up. This is just a journey. And hopefully at each step of the way, we're improving. But we can't improve if we're running from our problems. And guess what? When we run from our problems, what ends up happening is the problem is bigger and it's still there waiting for you at the front door. And you got to go through the front door. There's no back door. Okay. All right. So I'm going to deny the motion. Alter and amend conditions for a referral to Esperanza Court. And counsel, if you can contact Esperanza Court, I believe I want to say court coordinator over that is Christine Caceres, and that's out of Judge Stahl's court. If you can talk to them and let them know that he's willing to come back and follow their treatment plan. And I'm going to have him remain in custody until transfer either to safety or acceptance to Esperanza Court. But probation, I want him to be considered for Esperanza Court before safe P special needs. You're welcome. Is there anything else you need from the court? All right, you need to communicate and do better, okay? All right, is there anything else? All right, thank you.
Amethyst Garcia stood before Judge Stephanie Boyd with her future hanging in the balance. Already on probation from 2021 for drug possession, she was back in court for violating its terms by committing a new, more serious drug offense in 2022. In a strategic move, she pleaded true to the violation, hoping for leniency on the new charge. Her attorney painted a sympathetic picture, a mother of 5 daughters, aged 9 to 5, who had recently lost her grandmother and brother. He argued she had finally realized she needed to change, had a job waiting, and family support. He asked the court for another opportunity, proposing outpatient treatment so she could work and care for her children. But Judge Boyd, after reviewing the PSI report and Garcia's history, was unmoved. She acknowledged the defense's pleas but focused on the undeniable facts. "I'm looking at your criminal history," Judge Boyd stated, her voice firm and clear. "And sometimes people are learning their lessons, but your criminal history is not good." She pointed out that the defendant had been given plenty of interventions in the past and had failed to take advantage of any of them. Then, Judge Boyd delivered the decisive blow, directly connecting her past leniency to Garcia's current failure. "I previously had you on probation to work with you," she explained. "And I give them conditions to have tools to be successful. And what you've done since you've been on probation is not report, you just picked up new charges. And I can't have that." With those powerful words, Judge Stephanie Boyd effectively destroyed any hope of probation. She revoked Garcia's community supervision and sentenced her to 5 years in prison for the original case, running concurrently with a 5-year sentence for the new charge, along with a $1,500 fine. In her final remarks off the record, Judge Boyd offered a sliver of hope, advising Garcia to stay on the straight and narrow for the sake of her daughters when she gets out. It was a somber lesson in accountability and the finite nature of judicial second chances.